A little bit of background about the Opignani Humanist Legal Center. I'm sure if you guys are part of the local humanist chapter, you're familiar with the American Humanist Association. We are the legal arm of the National Humanist Organization. We were launched in 2006. We started off just doing amicus briefs, so they're friend of the court briefs, and we sort of turned that around into our own, doing our own litigation. So I have argued cases across the country, about 24 cases in federal courts, ranging from California, Mississippi, Virginia, Maryland. We've been all over the place, with mostly successes. Although we do litigate a lot of our cases, I do a lot of cease and desist letters, demand letters. So before going to court, I always make it a policy to try to resolve the issue before taking the government to court. And most often that is a successful situation. When it's not successful, that's when we usually end up in court. So most of our activity actually does center around the non-litigation letters in terms of our sort of successes. But we do have, usually we've managed about 10 cases at a given time. And that is quite a lot for how small staff we are. We actually have typically just been 2-attorney operation. We now have a paralegal, and I have a fabulous intern from Vermont Law School, which is where I went. So it's nice to have someone from that part of the country with us. I am actually from the Bay Area. I'm here in Marin. I moved back here from Washington, D.C. last year. I've been teleworking, so this whole working from home situation is not new to me, but the whole not being able to leave my house part is new. So that, and I haven't left in about 22 days now. So a little stir crazy, but trying to keep things pretty normal for the most part. I realize that it's everyone's kind of goes in waves of anxiety and stress about the world. And, so we're all just doing the best we can at the AHA to keep business as usual, but also take a pause to appreciate sort of the magnitude of what is going on in our country and internationally, as humanists do. So I'm going to talk about the Bladensburg Cross case. I'm not sure, normally if I were to give a presentation live, I would do some version of a show of hands of how many people are familiar with the case. I will just assume that some of you are not, so I'll give some background about it. But normally these end up being a lot of Q&A because I did have the experience of arguing the US Supreme Court, and people tend to have questions about what that experience might have been like, what the justices might have been like, what it felt like to, prepare for your first and probably only Supreme Court case, and that kind of thing. But I will focus on the litigation aspect of it too, just because it is sort of become a pivotal case in the separation of church and state world and the ramifications of the decision for our other cases. So the Establishment Clause is the separation of church and state provision of the First Amendment. So the bulk of our cases are focused on the Establishment Clause. A few of our cases we've brought also an equal protection type of challenge, saying that you can't favor, say in the prison context, you can't favor Rastafarian and Christian and Muslim inmates over humanist inmates, and that is sort of an equal protection issue too. But mostly we focus on the Establishment Clause, and the case law at the time that we brought this case, which involves a large cross, which I'll get to, had been very much in our favor. So to backtrack, so the Bladensburg Cross is this giant 40-foot Latin cross that is on government property in the town of Bladensburg in Maryland. It is one of the busiest intersections within this county. It's a DC suburb, so it gets a lot of traffic. And it is owned by a Maryland entity. It's the Maryland Parks Commission. And it was originally dedicated in the 1920s as a World War I memorial. And it was always kind of on government property, but the American Legion did help sort of build it. Over the years, the government took more of an ownership over it to the point where they actually have dedicated over $100,000 of taxpayer money to restore the cross when it started crumbling. And then recently, around the time we filed this lawsuit, they set aside another $100,000 because the cross was continuing to deteriorate, largely due to the atmospheric pollutants that formed the location that it was in, because it was a centerpiece of a big median and there was all sorts of traffic pollutants. So the cross, because of its concrete nature, perhaps I have a picture of it right here. You can just see it's this massive thing. You cannot miss it when you come in. There's no physical indication anywhere when you're driving through, and I've been to the property a number of times, that it is a war memorial, because there's been bushes that obscure the plaque. There's no pedestrian access. In fact, I was talking to Nina Totenberg before the case, and she said she felt like she risked her life trying to get into the actual cross, because there is no legal crosswalks, and so you're navigating this really intricate traffic pattern. All of which is to say that a passerby coming through the town of Maryland, say you're coming from DC, all you see is the town of Bladensburg and this giant cross, to instantly associate the government with Christianity. We didn't know it was a World War I memorial until maybe very close to litigation, because like I said, there actually was no way we could know, because the bushes had been obscuring any plaque, and even when the bushes are removed, the plaque isn't visible. More importantly, at the time we filed this case, the case law, especially here in California with the Ninth Circuit, was very clear that even when the government, maintains a cross for war memorial purposes, it is unconstitutional. It violates the separation of church and state. And in fact, some courts, including the court that we came out of this appeal from, the one that we won in, and I'll get to that, they've all agreed that actually kind of makes the problem worse, because you're marginalizing people who deserve veneration and respect. You're saying that Christians, deserve this honor, this is their cross, this is their memorial, and kind of everyone else is left to not have that kind of symbol of their religion or their faith. I also think it sort of plays into that sort of American Legion notion of God and country, or associating patriotism with Christianity. So there's a lot of reasons why the fact that it's a war memorial does not change or make the Establishment Clause problem better. It does make the PR side of things more difficult, and it definitely makes me more subject to, death threats and that kind of thing, because you're dealing with a population that is not wanting you to take away their giant religious symbol. To be clear, we never actually said that the cross has to be removed. That would be our preferred approach. We didn't say tear it down. We said you can move it. The state of Maryland had moved other giant crosses and big old historic houses. They had the capacity to move it. We thought it deserved to be moved to private property due to, again, the fact that the cross was crumbling in its current location. It was a safety hazard. So for a lot of reasons, we thought it would be more appropriate to be moved or reshaped. So we brought this case in the U.S. District Court of Maryland in 2014. And again, at the time of it, we filed this, the case law was very much in our favor. Courts had ruled that war memorial crosses were unconstitutional, non-war memorial crosses are unconstitutional, all because of the obvious reason that the government cannot prefer Christianity or Christians, if it's a memorial, over non-Christians, humanists, atheists, and so forth. So the district court surprisingly said the cross was allowed, and this was a big shock to us because, again, I just had won a case in the U.S. District Court of California involving a smaller war memorial display that involved like a cross etched into this really kind of ugly thing. It was Lake Elsinore. I don't know if you've heard of that area, but it was ugly. We were able to stop it. We won in the district court, easy peasy. This court was not as easy. So we appealed to the Fourth Circuit Court of Appeals, and I argued that case in front of the Fourth Circuit in 2016, and we won. It was a really good ruling because the court agreed with our position that the fact that a cross is a war memorial doesn't make it less religious. It actually makes the stigma towards those who are excluded worse because they are, those who deserve this kind of commemoration. We shouldn't be using a cross for war commemoration when it's a government war memorial. And then the other mitigating factor the government tried to argue was that it was old. It had been there for about 100 years. And I made this argument that the longer a county or, a township and citizens that are living there have to, see this connection and association. And we're not talking a small little cross. I mean, we're talking a 40-foot giant cross. You can't ignore that feeling that you are somehow an outsider. That argument also ignores the fact that there are many newcomers in town that wouldn't know the history. You don't automatically know it's a 100-year-old cross when you see it. And again, we weren't asking for it to be torn down. So we got this really great ruling from the Fourth Circuit Court of Appeals. And I did have a little quote here that I wanted to read about it, just because, like I said, it was such a good ruling. Let's see. So even in the memorial context, a Latin cross serves not simply as a generic symbol of death, but rather a Christian symbol of death, the symbol of Jesus Christ. Displaying the cross, particularly given its size, history, context, amounts to excessive entanglement because the commission is displaying the hallmark symbol of Christianity in a manner that dominates its surroundings and not only overwhelms other monuments in the park, but also excludes other religious tenets. The display aggrandizes the Latin cross in a manner that says to any reasonable observer that the commission either places Christianity above all other faiths, views being American and Christian as one and the same, or both. So great ruling, consistent with the other circuit courts, and the odds of the Supreme Court at this time taking the case was unfathomable, because the Supreme Court it rarely takes Establishment Clause cases. When it does, it's usually because they have to settle a dispute among the circuits, but the circuits had at this point been unanimous in finding cross displays unconstitutional in this context. So the government and the American Legion, I should also say that we had two opponents. It was a very David and Goliath situation. The American Legion was allowed to intervene because they claimed this sort of historic stake in the cross. So they were on the government side, and then we had the government, and then American Legion ended up getting this big law firm, Jones Day, to represent them. So we were up against the government and the American Legion. So every time they filed a brief, that meant I got to write two briefs, and work twice as hard with just myself writing it. So it was a lot of work. They filed a petition for rehearing en banc, which means they wanted the whole Fourth Circuit to reevaluate this panel ruling. Fortunately, that was denied. So that's another indication that this case is not going to the Supreme Court. Usually an en banc ruling could end up going there. We didn't get that. At this time, we're now in 2018. This is a time in which Kennedy was still on the Supreme Court, and Justice Kennedy had language in some of his rulings on the Establishment Clause. When he spoke about crosses, he had a position that was basically like a large cross on government property would clearly violate the Establishment Clause. And he said that in the context of saying that a small nativity scene, on a courthouse lawn for a couple of months or for a month is really not that big of a problem. Juxtapose that with a giant cross, I'd find that to be a problem. So we have a justice on this bench who, if you're familiar with the Supreme Court, Justice Kennedy's was considered the swing vote. So again, from where we're standing, we've won this case. There's no way the Supreme Court's going to take it. They filed, both the American Legion and the government filed their petitions for certiorari in the Supreme Court. So I had to write two responses to those. Then Justice Kennedy announced his retirement, and then Kavanaugh, the confirmation hearings for Kavanaugh started happening. All of this time, the cert petitions are pending on the Supreme Court's calendar, and they kept bumping it from their calendar to the next week or the next week and the next week, to a point where our case got kind of bumped from the consideration calendar. I think it was 20 times. And I found that to be really odd. This was maybe only the third time I've had a cert petition situation in the Supreme Court. But I never had it bumped this many times on the calendar. So I talked to other experts that have argued more cases in the Supreme Court. I talked to SCOTUS blog, who had been in touch with me about my case. And I said, is this normal? Do cases get bumped this much? And she said, no, I have not seen this. So we were all scratching our heads. Why does this case keep getting bumped and bumped and bumped? And then I have this written down because I just don't remember all the dates, but on October 6th, 2018, Kavanaugh gets confirmed in the Senate. He's confirmed. And then about 2 more weeks, around November 2nd, the Supreme Court granted the case. So, and all they needed was 4 justices to grant cert. So I'm fully convinced that Justice Kavanaugh was the single-handed reason that was their 4th vote. They didn't have Kennedy. They wouldn't have had Kennedy. And that is very scary, because it is a telltale sign of why elections matter. And, this whole time with the, during the Trump-Hillary election, all I kept thinking about was the Supreme Court. And this was a just quintessential example of why that is a problem where we were at. So they granted certiorari, and then I gave the oral arguments in February, on February 27th, 2019, so almost this time last year. And it was scary. We had my opponents, the US government also wrote an amicus brief, and they were allowed to intervene at the Supreme Court. So I was arguing against 3 seasoned, they each got their own time slot. So they gave me an extension. I had more time than most litigants do because I had to respond to 3 people. They had extra time. The US government, the Maryland government, and that was argued by Neil Katyal, who is kind of a moderate person, but he's argued tons of cases. And then the Jones Day, like senior partner at this big DC law firm, was arguing for the American Legion. And then I had, I forget his name, Wall, but like sort of the US deputy, I forget his title, but so these are like big people. And this was my first US Supreme Court case. And it was just me at the table. And then their table was like full of associates and paralegals and all this stuff. So it was pretty wild from that lens. We did lose the case, but when the Supreme Court granted the case, there was no chance in hell I was going to win this thing. They don't take cases like this and you win. So my whole approach was damage control, because the arguments that our opponents were making were essentially trying to get rid of Establishment Clause, get rid of separation of church and state as we know it. They wanted the court to overrule the test that's typically used in these cases. It's called the Lemon test. It is basically the only way you really can analyze a lot of these issues. They said, do away with that. The rule should just be that the government can't force you to go to church. Everything short of that, some version of that, or, they can't establish a national church or a state church, but, if it's just a cross or prayer or anything, then it's okay. So they're putting these arguments out there. They've got all sorts of support from organizations, filing amicus briefs, friend of the court briefs, imploring the court to change the entire meaning of separation of church and state. So my thinking was just, how do I get them to narrowly uphold this cross and not do away with anything else? And I feel that was accomplished. We lost. The court said this cross can stand. It was a fractured plurality ruling in the sense that they could not agree on the standard as to why we lost. You had several justices saying that it's for standing reasons. So Justice Gorsuch said he was only concurring in the result, and that was based on, he didn't think we should even have standing to bring the case. And you have Justice Thomas, who doesn't think the Establishment Clause should even apply to the states. And then you had Breyer, who felt that the age of the cross was relevant, and you had Kagan, who thought that it was the World War I connection, so not any war memorial, but the fact that World War I had used crosses as well as Stars of David. She felt that made the cross more special. She had also argued for the government in a similar World War I case in the Mojave Desert. She argued that case for the government, so she had already formed this association between a World War I memorial and the cross, the Latin cross. So it wasn't a surprising ruling, nor should you find it surprising that Ginsburg dissented along with Justice Sotomayor. It was an amazing dissent. She read it from the bench, which was sort of a statement in itself. And that decision came down on June 20th of 2019. So like I said, it was an expected loss. The fact that they didn't overrule the Establishment Clause precedent that I wanted them to not overrule was amazing. The case really is kind of narrowly confined to old monuments, arguably old war memorials, arguably old World War I memorials. This is a very narrow ruling. That doesn't mean it's not going to be used by our opponents to try to broaden, to misconstrue it. And we're already seeing that. In fact, we lost another cross case that wasn't as old, wasn't a war memorial, but it was a Trump-appointed judge who was leading the show. And it was an expected loss. We filed that case with Freedom from Religion Foundation in Florida. We knew we'd lose after losing Bladensburg, but other than that, we've continued to win cases in the lower courts, notwithstanding this ruling, that we wouldn't have been able to win if the court had done away with the precedent that I was talking about. So here is a little picture one of those court sketch people ended up doing. You can see me, justices, it was scary. This cross right here is the Pensacola cross that ended up being upheld in Florida. Our position was just to not challenge it, not to take it anywhere right now, because we can overrule that later. It's just a 3-panel ruling. We're accepting the loss, and if there's a different Supreme Court or a different 11th Circuit in 5 or 10 years, we'll go and challenge different cross in Florida and get that case overturned. It's just not the timing for that. But like I said, we did continue winning cases after this ruling. We won our case in Carroll County, Maryland for legislative prayers. That's when the government, has a county meeting and they decide to open it with a prayer. We argued that the government cannot itself be the prayer giver, and that's at least the case in the Fourth Circuit where I argued that case. And so we did win that following the Bladensburg ruling. We also won our very long-standing case in South Carolina over school board or school prayers and using a chapel for elementary school graduations. The opponents tried to raise Bladensburg against us, and the court agreed with us. It didn't have any relevance to the issue of school prayer. So we ended up getting a large injunction against one of the largest school districts in South Carolina, saying you can't have these graduation prayers. There was sort of a small little loophole, but it basically would all kind of wholesale prohibit them from doing that. We still have a case pending in Arkansas challenging a new 10 Commandments monument. People might be familiar with that. It's been, we are bringing that case with a bunch of other groups, including the Satanic Temple. And we're very confident that the Bladensburg case won't have an impact on that due to the fact that this is a new monument. There's a lot of religious purpose surrounding it. You've got a government official making all sorts of religious statements. So we also have a case against Florida Police Department involving a prayer vigil that we are confident the Bladensburg ruling will not affect. We already won the case. We're just waiting on sort of the final aspects, attorney's fees and that kind of thing. They are trying to appeal it, but I still, like I said, feel very confident. And we are about to bring a few more cases, humanist prisoner cases, some school type of cases that will not be impacted by Bladensburg. So that's kind of our continued advocacy. And I'm just trying to think of what else I want to say before opening it up to Q&A, because I know we're kind of early on that. I guess what I would say is that with respect to the justices' decisions and it being fragmented, I think a lot of people were disappointed. Justice Breyer, who is Jewish, had ruled in favor of this giant cross. I wasn't surprised because there was another ruling he had upheld. It was for a 10 Commandments display in Texas, and he relied on the age of that monument. It was 40 years old, and the fact that it was in a park surrounded by it was the Capitol grounds, but they had all these other monuments that were of equal size, sort of scattered about. So he felt that sort of negated the religious meaning of the 10 Commandments. Here, he also felt that it was the age and the context that sort of negated the religious meaning. Then you had justices who said you can't negate the religious meaning of the cross, but the government can still promote Christianity anyways. So that's kind of like your Alito basically had that position. So yeah, I mean, I guess I also have at the end of my slide, because normally I would do this more as a slide thing, just sort of my contact information, but just if you have reports for violations or that kind of thing. But since we have more time for Q&A, you can ask me other separation of church and state type of questions. Doesn't have to be about this cross case, but I do have my email. It's mmiller@americanhumanist.org. So if you do have questions down the road about church-state separation, I'm more than happy to answer them.
I want to say that's horrifying, trying to take down the Establishment Clause, but I wondered if you could comment about Project Blitz or whatever it's been renamed to. You know what I'm talking about?
Yes. Okay. It is a concerted effort by the Christian conservative right to do exactly what you're talking about, which is to get rid of separation of church and state as we know it. It is a planned effort. So they're sort of starting with things like In God We Trust. They're trying to get that up in courtrooms, on police department cars. They know that the precedent basically allows it. The Supreme Court has issued some rulings that basically say God We Trust is fine. So they're taking this sort of dictum from the case law, just sort of statements, and they're saying, let's steamroll this into this. And so they're really taking this very aggressive, approach that was leading a lot of the amicus briefs that we were seeing in the Supreme Court case that I argued. It was like almost like they all wrote the same brief. It's like they have the same agenda here. I will say, and I forgot to mention this, that one of the sort of silver linings or highlights of this case for me was working with religious allies. We had a lot of Christian groups on our side, organizations and churches representing millions of Christians in America were siding with us. And I really thank the Baptist Joint Committee for leading some of those efforts. I've ended up being really close with some of their attorneys. They were there on the front of the court steps, advocating on our side, even though they're devoutly Baptist, devoutly Christian, for the very obvious reason to me and to them that why do you want the government to be able to co-opt your most quintessential Christian symbol? The government's argument, so the American Legion's argument and a lot of the amicus briefs was basically, this is a Christian symbol, but it should be allowed because the Establishment Clause, separation of church and state, shouldn't exist as we know it. The government, on the other hand, and the government's position sort of prevailed here, was that this particular cross is just not that religious. It's a war memorial. It doesn't symbolize Christianity. It symbolizes World War I. Well, a lot of Christians found that to be very blasphemous, and they don't want the government to define their religious symbol. They don't want the government. They don't want that in the hands of the government for the same reason devout and not Christians with less of an agenda wouldn't want public schools to teach their kids Christianity because they'd rather their pastors do it and not the government. It's because that's why we have separation of church and state. It's not an atheist provision. And if anything, they have way more to lose. We have to look at the cross, but now you have a government being able to say, this no longer stands for Jesus. This stands for World War I. So we had millions of Christians represented by Methodists and I think Seventh-day Adventists, Baptists. I'm trying to remember the other ones, but the kind of national organizations for these groups on our side. So that was pretty amazing. And I now will be working with those groups in future endeavors because it really kind of opened my eyes to their argument, which again, they have more to lose, and a lot of them did feel like they lost when the cross was able to stand. They see a bigger picture here. It's not about this one cross. It's about each time, with these Project Blitz things, what are you doing? You're now God, the reason why God, in God we trust, like I said, with Project Blitz, that sort of was one of their first efforts that they're trying to get in courtrooms and stuff. The Supreme Court's basically said that God in this context has no meaning. It doesn't mean God. We kind of know it does, and we know it's religious, but they're watering it down to the point where it loses its religious meaning. And why would you want that as a religious person? It doesn't make sense to me. So yeah, I know that was kind of a longer answer to your question, but I just wanted to mention that.
Yeah, it was a very good answer. Thank you very much.
Monica, first of all, thank you very, very, very much for the work that you do. I think this is really, really important stuff, and I'm happy that somebody's doing it. So thank you very much. I think the title you were looking for was Deputy Solicitor General.
Thank you.
Yeah.
This coronavirus pandemic stuff has been great all over the place.
I'm just curious about the ruling. You said that there was a lack of consensus on what the rule should be, and how it should play out. Do you think that's going to encourage those who want more religious monuments to bring more court cases around this area of the law?
That's a great question. I do think they're going to try to manipulate this ruling in the favor of more religious monuments, but the ruling, there is a thread that can be deduced from the ruling, and Alito wrote the sort of main opinion, the plurality part of it, that most of them agreed on, that the fact that this was really old mattered. The fact that this was World War I really mattered to the majority of the justices. So with respect to building new monuments, that's pretty much out of the question. In fact, if anything, I would argue that the case implicitly says you can't build new monuments because of the way they were writing and how they phrase things. So unless, maybe if it's a non-religious thing, but a new cross really should not be able to withstand this court's ruling. Doesn't mean they won't try. It doesn't mean that we're going to not have to fight like tenfold. We're really I always sort of analogize it to almost like a football field or something where, I started my career here maybe 10 years ago more, we're like center kind of on the defensive side, but we kept winning cases and kind of over here since the Trump administration and all of his judges and justice appointments. We are really far down on this defense. I don't even watch football, but I just understand sort of how the field works. We're so far over here that we have to just kind of push our way back. So they know that. So they're just piling on, kind of wearing our groups down, because there's only a handful of us that are arguing these cases. And they've got Beckett Fund and Religious Liberty, First Liberty, and these huge, heavily funded, the Federalist Society, all of these forces against us. So yes, I do think we'll see more monuments. Yes, I do think they'll try to use this ruling in their favor. And again, we're just going to have to fight harder and hope that a different president comes soon and reappoints people that are more in our favor.
With air quotes, amen.
Hi, Monica, thanks for doing this.
Yeah.
So you were talking about how in the Bladensburg case, that seemed like the main issue when the Supreme Court took it, that the main issue being the issue of age, that because it had been there for so long. But then when you spoke about the cross that was located in Florida,
Yes.
you mentioned that one was not there that long. Yeah. And I'm not sure, I guess that the one in Florida had nothing to do with with being a memorial for any war or anything like that. But the fact that you said that you were going to wait, in other words, not appeal the court's ruling, but just wait, that seems to imply, I guess, that you're worried that the current court would just find some other reason other than age, since that age is not an issue on the Florida one.
Great.
Is that it? What is the other things that you're worried about that the Supreme Court would use to allow the Florida cross to stand?
That's a really excellent question. I'm glad you asked it. So I wouldn't say I misspoke. It's not as old. And there was a factual dispute. This 11th Circuit ruling was one of the worst rulings, because we had won the case in the 11th Circuit. I argued it. It was this Trump judge's first day on the 11th Circuit. I was like, lucky me. He was really prepared to just demolish me. I still won, but his ruling was basically I don't want you to win. So he was maybe 2 paragraphs of why we won. And then he wrote his own concurrence to himself about why we should lose. Then he got the opportunity after Bladensburg, because the Supreme Court, it was pending in the Supreme Court, the Pensacola cross. And the court just didn't want to deal with it. So they said, it involves a cross, go back and figure out if the ruling is still valid in light of our decision. So they already got this sort of, not even hint from the Supreme Court. It's very typical to do that if it's the same subject matter. And so the 11th Circuit, the same Trump judge, took the same opportunity to now take what his previously in his concurrence and put it in the body of it. The problem, one of the main concerns, so 2 things. One is that that cross was still old. So it was still in it was the 70s that they put it up, but the government, the city of Pensacola, was arguing it was actually put up in the 40s, and they had temporary crosses replace it. So the 11th Circuit favored all of their facts. So they said it was older, and even in the 70s, they still said, whatever, how long that it go, 60 or I don't know, my math again, forgive my factual stuff. It was old enough in the 11th Circuit's mind. There was no war memorial association to this, and yet the 11th Circuit forged one. They said it was built in the time of Vietnam War. It was put up, it kind of even contradicted the age component. They found a stretch to say it was war memorial when the district court judge, who was very conservative, never ruled in favor of civil rights plaintiffs. Somehow I won the case. He was the district court judge that I won the case for this Pensacola cross, was on the Pensacola JCs, the group. He was the president of the Pensacola JCs at the time they put up the cross. So he was he had a personal stake in it. He said he walked by the cross every day on his way to the courthouse. So I'm sitting there being cool, I totally have lost this case. Maybe I can get him on bias. And so the fact I won with this guy and not this Trump judge should tell you something. And I say the Trump judge because there was another judge on that panel who was a senior, he's already a retired status judge from I forget even what district court, but they pulled this guy from the ether. And I'm like, why? They have other 11th Circuit judges appointed by Obama. I have no idea why I'm getting this panel. It was I'm not a conspiracy theorist. I just think that every judicial selections for panels, litigators really don't know how that happens. So all that's to say, they did forge that. The concern we had was not what the Supreme Court would do. It was actually what the 11th Circuit could do. The ruling against us for the Pensacola cross, that same Trump judge, his name is Newsom, wrote a very long concurrence about why we shouldn't have even had standing to bring this case. And he said, because he doesn't have the authority to overrule the standing doctrine in the 11th Circuit, because they need the whole panel, the en banc, it's called en banc, they need them to make that decision. So he's petitioning, he's basically saying, hey, colleagues on the 11th Circuit, if they file for en banc, let's take the case and decimate standing. If standing's gone, we can't bring any cases in the 11th Circuit, because if citizens that live in the county who have to walk by the cross all the time don't have a direct injury to bring the case, no one can bring Establishment Clause cases. So this Trump judge, probably part of the Federalist Society, in fact, I know he is, they have this kind of like Project Blitz agenda to not even let us get our foot in the door. So we're looking at this decision saying, not even thinking the Supreme Court level, we're thinking if this 11th Circuit, then we can't bring another case in 10 years when the circumstances are better, because we won't have the standing to do so. So having looked at that ruling, we were like, let's just not touch this. I mean, it was a hit, but we expected it. We were prepared for it. You know, it was unanimous with me and Freedom from Religion Foundation lawyers were like, let's just wait this out. It's Florida. It's the 11th Circuit's the worst. It's always been the worst circuit court. It's now worse than it was before. So it sucks to lose something that is so obviously wrong. It wasn't a war memorial. It just, yeah. So sorry, it was another long answer.
Thank you. Thank you very much.
Yeah, Monica, I just want to second what somebody else said. Thank you so much for the really important work you're doing. Start my video. Hi. So I have a question about the Arkansas 10 Commandments case. I'm part of the Satanic Temple, so I've been following that
Awesome.
Fairly closely. And I just was wondering how good you think your chances are in that case, to prevail over the 10 Commandments.
Great. I mean, maybe I'm hopeful and optimist, because I really shouldn't be at these times, but I do feel like we have a good judge. We have been winning kind of our discovery motions, and we have little hints and indications that we're gonna win. Now, on principle, we should win, because like I said, there's statements left and right about its religious nature. The first one had been rammed into, they rebuilt it, they got funding from churches. I mean, the circumstances are so different than the Bladensburg case. It fits squarely within another Supreme Court case, McCreary County versus ACLU, where they said a new 10 Commandments monument where there's religious statements by public officials that are made at its dedication ceremony. It's not displayed amongst, 20 other equal-sized monuments. It stands alone, that, and it's new, that's a problem. And so we have exactly that here. So unless the Supreme Court, we have to win, in the 8th Circuit, that doesn't mean the Supreme Court, if they end up taking this case now, that wouldn't surprise me, because I've already had them take a case. So, I don't want to say 100% we'll win. I'd say in principle and in precedent, we absolutely should win. In terms of the judge we have, we should win. But I experienced firsthand that things can go smooth sailing and all those things can check off, good judges, all that, and then the Supreme Court takes it. So
you think there's a good chance it might make it all the way up to the Supreme Court?
I don't know. I really don't. Everything's so different these days. I think if Trump wins this upcoming election, I do think that we will see the Supreme Court taking more religion cases and ruling in ways that are anti-humanist and against separation of church and state. So I think the odds of this case, especially given its controversy and the amount of groups involved, I do see this one has the potential to get to the Supreme Court with this Supreme Court, or one that's, even minus some of the progressive parts of the Supreme Court who maybe won't last another 4 years. So.
Yeah, I just also wanted to make a comment that I personally, with the Satanic Temple, was planning a event, a kind of satanic response to the Bladensburg Cross, because I live in Maryland, and unfortunately had to be postponed. It was supposed to happen 3 weeks ago, I guess.
Oh, yeah.
We're still planning to do it in the when the opportunity arises. So
cool.
It's definitely very much on our radar.
Cool. Well, keep me posted.
Yes, Monica, you've mentioned a couple of times the Federalist Society, and of course, they have a undue influence over the Supreme Court. What is the future of that? Is there any organizations that are trying to counter their power?
Yeah, great question. I mean, I think feasibly countering their power is probably not in the cards, but at least getting closer to that mark, definitely. The American Constitution Society has traditionally been the other kind of progressive arm of what they are, the Federalist Society. But frankly, the Humanist Legal Society that we formed 2 years ago, I believe, the one in which I sort of lead, is the goal is for us to be, we know we'll never be as big as the Federalist Society, so we're not purporting to do that, but we'd like to kind of eventually operate like one in the sense that we have some sort of influence over judges. We have already held 2 events at the National Press Club. We've had events at others. We had a 10th Circuit, was it 10th? He was a 10th Circuit judge come visit us in Colorado at one of our speaking events. So we've definitely are hoping to at least be a counterforce to the Federalist Society and take the arguments that they're making and put them in a panel format with experts and explain why they're wrong on things. In fact, when I was in law school, when I started more getting into separation of church and state stuff, the Federalist Society and the Christian Legal Society were such strong forces on Vermont Law School, which is a very progressive school. So I went. I also do animal law on the side. I actually work for a group called the Non-Human Rights Project. And at the time, Vermont was one of the only schools that had courses in animal law. So very progressive school. So it was kind of disturbing to see how much of a say the Federalist Society had there, as a student club, and the Christian Legal Society. They were kind of clogging up the student inbox with like National Day of Prayer and that stuff. So I actually formed the Secular Law Student Association. Not that I had extra time to do that, but I felt like we needed a counterforce to those messages, even just on like the email chains, to say National Day of Reason. And that's when I started getting involved with AHA and started interning for them over the summer. I don't know if you guys are familiar with Michael Newdow, but I asked him if he needed any sort of volunteer student research kind of stuff. And so he had me doing some projects at Library of Congress that summer in DC. So yeah, that was my way because I've always felt that we need to sort of counter these messages, or else, like again, with my football field analogy, we'll end up way far here because of the resources. So yeah.
And I just had a question, more philosophical than legal, that there are many kind of national debate also going on related to the Confederate monuments and how painful it is to remove them, should they remain in place. And at the University of Texas, some have been removed. And so there's that debate going on as well. And there's also a historic issue of what a lot of people don't realize is that these military monuments, for the most part, they sprang up after World War I. Before then, there really were very few of them. There's a German scholar named George Mosse, M-O-S-S-E, and he wrote a book about the cult of the fallen and how this whole phenomenon was toxic in inflaming passions for World War II. So I'm just wondering, might there be some other approaches that can be taken as well that might reach an audience that might not be moved by the arguments that have already been laid out?
Yeah, I mean, one thing I do want to comment on, because I ended up making this a big point of my argument, is that context really matters. So when we're talking even about the Confederate monuments, whether they're Confederate flags or, monuments that are, putting literally like a Confederate soldier on display, which they have a lot of those in the South, the right context for displaying them. So it's not to say, let's get rid of every, thing that reminds us of bad history, but it's how we display it. And so I was even thinking with the Bladensburg Cross, what a perfect kind of making it more like a museum, an actual museum. Like, hey, even putting up a big sign that says, this is a World War I memorial put up by American Legion, all this kind of context. So it's no longer the state saying, welcome to Bladensburg, here's our cross, but more of an educational thing. It was put up here. Something that's actually visible. Having a World War I museum, let's say this was smaller and easier to pick up and move, which they did for the 9/11 cross in New York, which is really displayed in an actual museum. So you don't have this connection between the government. When it's in a museum, you look at it as history, or you look at it as an important part of a story, you don't look at it as the government endorsing it. So when it comes to a Confederate flag, it's very different to see it in a Civil War museum, say, even if it's the state of Arkansas Civil War Museum. So the state owns the museum and puts the flag inside of a display case, versus having it on the Capitol grounds of Arkansas, just right there. Like one is saying we endorse this is our flag. The other one's saying this was a flag that was used in Civil War. So I do think that making things in a museum-like context really actually, in fact, it doesn't negate the religious meaning of the cross. So putting that cross in a World War I museum doesn't say this cross is less religious. It says the government's negating or separating its imprimatur over that symbol. So I know that doesn't exactly directly address your question. I did immerse myself in a lot of literature about commemoration and war memorialization. I worked with this fantastic expert witness who had studied and written all sorts of works on, again, World War I, especially in its aftermath, and the use of religious symbols in war memorials and the lack thereof. In fact, the doughboy was the prominent symbol. So yeah, I don't have much to say on what is a more appropriate way to commemorate, and I don't necessarily say statues or monuments are wrong. I do know the concept of the living memorial has more traction, maybe a sidewalk or a park being a memorial, or trees, or something that's kind of more productive or is used and it's not just seen. I think I like that concept personally, but I definitely do not think that the government has any business using a single religion's symbol as the method to memorialize the war dead. I think that's completely inappropriate. But short of that, I don't have a strong legal opinion as to what to do with respect to the Confederate flag and that stuff. I think it belongs in a museum, if at all, and certainly not in spaces where it's not seen as a museum, but seen as the government saying we're racist,
The scheduling of the Arkansas trial going to be changed at all because of the pandemic? Because I thought it was supposed to start like really soon, wasn't it?
Yeah, so a lot of our deadlines have kept getting pushed out, and largely due to the state of Arkansas being less than cooperative during discovery. So we keep having that deadline pushed out, but now with the court closures, I do not think it's coming. I think we're going to get more. I think we're going to see probably 2021 where we actually end up arguing this case, to be realistic, because I have cases before the pandemic, federal cases where it just sat for a year. The federal courts have been backlogged. So to me, I do not think we will have a ruling or even get to argue this case for quite some time.
I think their argument against the Satanic Temple is that we weren't a real religion, as that was what they were attempting to argue. But in fact, that this case in Scottsdale, Arizona, we lost that case, but they upheld the fact that we are a real religion.
Yes, yeah. I worked closely with Stu behind the scenes, the lawyer, because it was his first sort of civil rights case. And like a lot of us, you get really nervous when you do your first one. And being a criminal lawyer is very different than being a civil rights lawyer. And in fact, after he lost that case, he sent me a very sweet message about how much gratitude he had for what I did, because these cases really do take an emotional and mental toll on you, especially when you lose, but kind of the vitriol and death threats and stuff you get just by bringing the case is a lot. And then dealing with opposing counsel who are very difficult often in these cases, stonewalling, being negative. I know he dealt with a lot of that. And he's like, the fact you've done like dozens of these cases now, he's like, so I'm like, and to me, I look at a criminal defense lawyer and I'm like, I can never do that. That seems overwhelming to me. So but it's nice to have that relationship with Stu and help if I can.
Thanks for being a satanic ally.
Of course. I guess, one other thing you guys should know as fellow humanists, that I found myself in the Supreme Court, I use my hands a lot, and I got a question about whether it would be appropriate if they maybe if they endorsed a humanist display or something, and I found myself standing before the Supreme Court trying to emulate the happy humanist. I found my hands going up, and I was like, the humanist symbol, it kind of looks like this guy, and he's in the air, and I was like, caught myself doing that. I'm like, I cannot believe I'm telling the Supreme Court the happy humanist is, but that is on the transcript. I did say that, and I feel very happy to have informed them of our symbol. So if I did nothing else that day, they know about the happy humanist.
I'm glad we have a symbol.
Yes, me too. Me too.
And it's a good one. Yeah.
It is.
How appropriate.
It is. It's happy. It's humanist.
If Trump is elected, how different is the planning and do you have a planning and then what happens? Will there even be a government if he afterwards?
Yeah. I mean, I'll answer the first part. There is a plan, and it's basically the plan I've been implementing, which is being way more strategic about cases. Like that 11th Circuit Pensacola cross case, there's no way I wouldn't have pushed forward with that when we lost just recently. But knowing the trajectory and how much worse the courts could get in a second term of him, I don't want to touch that. So I'm being very strategic with the new cases I'm bringing. I'm only bringing cases that I either definitely will win, or if I lose, there is little damage. You know, it's something that's nuanced that won't impact other cases. With respect to AHA broader, we are targeting more state legislatures and local governments to, you know, push our kind of humanist agenda or to block things. So we'll definitely have an increase in legislative activity, maybe less litigation for a while. You'll probably see me do more letters, like demand letters, and less stuff in court. Whether we, my guess is as good as yours for the second part of that.
Yeah. And thank you. You're a great hero.
Thank you.